Now it's time for America's Talking and Firearms Friday, with stories across the country that you can find in the description below or in your inbox with the Center Square newsletter, free at thecentersquare.com. The Washington State Supreme Court has ruled that individuals convicted of 2 DUI offenses within 7 years will be stripped of their Second Amendment rights, which the dissenting opinion blasted as a blatant violation of the U.S. Constitution. The Center Square Washington editor Andrew Paxton reports in a split 5-4 decision filed this week, the court reversed the lower court ruling and held that Washington legislature acted within its constitutional authority by categorically disarming repeat drunk drivers in the interest of public safety. Now, under Thursday's ruling, Washingtonians convicted of a second DUI or related crime within 7 years cannot own or possess a firearm under a 2023 state statute. Firearm rights can only be restored after a petition is filed following 5 consecutive years of law-abiding behavior in the community. Now, the respondents of this particular challenge, they challenged the law after their application for concealed carry permits were denied following multiple DUI convictions. They argued that a blanket categorical ban on their fundamental rights for self-defense, absent any history of weapon misuse or physical violence, violated their Second Amendment right, saying modern regulations do not require a perfect historical twin to pass constitutional muster. The majority on Washington's Supreme Court pointed to 3 enduring historical principles: the tradition of disarming groups deemed dangerous by legislatures, the tradition of restricting firearm possession for serious crimes, and founding-era regulations restricting firearm use by presently intoxicated individuals. Now, the ruling provoked a sharp dissent from one justice who warned that the majority had overreached by using speculative statistical correlations to strip citizens of fundamental liberties. The dissent emphasized that individual self-defense is the central component of the Second Amendment, and under federal precedent, disarming requires a clear threat of physical violence. Because a DUI lacks an intent requirement to the causing of physical harm, the defense argued that it cannot be categorically defined as a crime of violence. Now, elsewhere throughout the country this week, conversations about access to firearms and the Second Amendment right to keep and bear arms continues. In New York State, Senator Brian Kavanaugh praised the Empire State's gun control measures, among other priorities he says the legislature's achieved.
When I got to the legislature, the gun laws of New York were depressingly weak. You could still walk into a parking lot with a very dangerous weapon and sell it to somebody for cash with no questions asked and walk away and not be committing a crime. So the SAFE Act, which we did before I was in the Senate, and the continued work of this body on making our gun laws keep people safe, keep guns out of the wrong hands, has been an ongoing and very important thing. And we're passing more bills today to make sure that we live up to that commitment.
But some decry unforeseen circumstances and consequences of too many gun control measures. Justin Loeffler, employed in Nevada's private security industry, he testified to Nevada legislators this week about the barriers that he and others in that field experience to keep their weapons permits in good standing for their jobs.
After possessing or passing multiple background checks and demonstrating that I can legally possess and carry a firearm, why should an employer have the authority to prevent me from advancing my career? The VEAS requirement is not an inconvenience, it is a barrier to professional advancement. A qualified agent can deny a VEAS form for a number of reasons unrelated to an individual's qualifications, character, or ability to safely carry a firearm. The burden did not end once I became armed. Every 6 months, my ability to continue my career depended on whether or not I could get a form signed by my employer. I reviewed NRS 648 and NAC 648, and I found no law or regulation that expressly requires a VEAS form. I later learned that the board never voted to adopt the VEAS form as a formal regulation. Yet it's been imposed on employers, instructors, and working people trying to support and feed their families. This is a serious problem.
Now, in the Pennsylvania House, a committee hearing earlier this week Legislators discussed measures in that state to require firearms to be kept in a safe. State Representative Rob Kaufman discussed a troubling incident.
Just last month, in the city of Philadelphia, a mother awoke shortly after 1 a.m. to the sound of her apartment door being kicked in. When she investigated, she discovered a man she never met standing over her sleeping 14-year-old daughter with a large metal pipe. A violent struggle followed as the mother attempted to protect her child. Fortunately, an armed neighbor heard the family's cries for help and intervened in time, shooting and killing the intruder. Incidents like these demonstrate why many Pennsylvanians believe readily accessible firearms are essential for personal and family protection. This bill also creates significant enforcement concerns. How exactly would law enforcement determine whether a firearm was stored in compliance with this statute? The bill applies to firearms that are not in use, but fails to define what in use means. One could reasonably argue that a firearm kept for home defense is always in use because it is being maintained at all times for protective purposes. This legislation creates uncertainty for lawful gun owners, invites arbitrary enforcement, and burdens the exercise of our constitutional right.
Meanwhile, the Colorado Shooting Sports Association announced their lawsuit challenging a law there that they say allows Colorado's government officials to obtain firearm purchase records from gun stores without a warrant, probable cause, or even a stated reason. In a post on X, the group said the Constitution doesn't disappear when you exercise your Second Amendment rights. They say this law is about defending both the Second and Fourth Amendment rights, and that's why they're challenging that in court. And that's just some of what America is talking about. So get these and other headlines at thecentersquare.com.